you exercise, you read. You're like the epitome of any New Year's resolution. So welcome, ladies and gentlemen, to the Modern Lawyers Podcast. I'm here with attorney Gabriel Vigh.
It's a pleasure as always.
How's your day going?
It's almost the weekend.
Just a day in the life as a lawyer. So last week we talked about insurance policies and opening an insurance policy. So before we get into that, Gabe, can you tell me what insurance is, what an insurance policy is?
An insurance policy is a policy you purchase from an insurance company. Usually it's mostly motor vehicle policies or automobile policies that will insure you for a certain amount of coverage that they will protect you from if you're involved in an accident, you're responsible for causing injury. So
when you go to, let's say you're an insurance broker to get insurance, you'll say, I want to be insured at this limit. Do you give them an amount?
Exactly. Yeah. You'll kind of give them, hey, this is what I have as far as assets. This is what I want to protect. Now, the minimum insurance policy in California, which I honestly think is too small, is $15,000.
Sure.
That's the bare minimum requirement for almost every person in California. There's some lower insurance policies for people who don't qualify for income, but for the majority of most people, $15,000 is the limit.
I think that's kind of interesting. You said when you go to your insurance broker, you tell them, this is how much assets I have, this is how much insurance I want to get. So is there a correlation between assets and insurance?
You typically want to purchase insurance that's going to protect you from exposure to assets. So for example, if you have over $100,000 of assets, you want to purchase a policy that at least has $100,000 of insurance protection or coverage for liability.
So in case you cause an accident, in case you're at fault for something, that insurance policy will protect you and protect your assets.
Exactly. Insurance companies are supposed to protect you for, people make mistakes, any mistakes you make. So if you're responsible for causing someone's injuries, they'll protect you up to that limit. So for example, if you have a $100,000 insurance policy limit, the insurance company has a contract with you to pay up to $100,000 to prevent the person from suing you above that limit. If the person's injuries are above the $100,000, they may potentially have a claim, but the insurance company has an obligation under contract to protect you up to $100,000.
Okay. So in case this loss happens, does your insurance just cut a check and make sure that you're protected?
I wish it was that simple. Obviously, we would be unemployed though if it was. But no, that's not the case. But what many people do not know is that if you're responsible for causing an automobile accident and the person you injure, they have injuries that might be worth more than your policy limits in a case if it goes to court. Once the insurance company has sufficient information to assess their claims and decide or evaluate the claim above your policy limit, and they have a reasonable opportunity to pay the policy limit, they have a duty to you to settle the other person's claim for the policy limit.
Understood. So to break that down, if the insurance company notes that you are at fault and the injuries that you cause will exceed your policy limit, then they have a duty to pay out that policy?
Exactly. They have to have sufficient information and also a reasonable opportunity to do that. Okay.
Now, who's evaluating these cases? I mean, we're talking about injuries and we're talking about people being at fault. Do they have a team of police officers or doctors or who? What is it?
You'd be surprised who evaluates it. You have a lot of lay people. A lot of them, these adjusters are lay people for the most part. They may have a superficial understanding of medicine, very superficial. They'll take into your medical bills into consideration, but they really never really consider your full medical bills. What they'll do, and these insurance companies will do, is they'll hire these consulting teams or hire the software that evaluates what's a fair and reasonable medical bill. And that's usually a very discounted rate. And they won't reimburse you for the full value of your medical bills most of the time.
So you have these consultants and you have lay people evaluating people's injuries. And I mean, we're talking about medicine and medical, and we all know how much school doctors go to. I mean, they're students forever. But you have individuals that have no medical backgrounds evaluating these cases.
Yeah, it happens all the time. Now, typically when there's serious injuries involved or serious injuries alleged, the insurance company, they may retain a medical expert there to evaluate, our client's medical injuries, have them get an exam with their doctor. But typically those doctors are very conservative. They're very, very conservative. They wouldn't be retained by the insurance company if they really evaluated everything just unbiased.
When you say that they're conservative, I mean, are they putting a Band-Aid on a broken bone? I mean, how conservative are we talking?
I would say so. Sometimes, right? Obviously, if it's a broken bone, it's pretty easy for any doctor to tell. It's easy for a layperson to tell person's got a serious injury, right? Obviously, there's different severities in broken bones, repercussions that happen from broken bones, complications. But typically, any person can evaluate something like that. When it comes to like a soft tissue injury or something that's related to your disc or your spine that's a little bit more complicated, these doctors, they're very conservative about that treatment. What they will recommend is they'll recommend the least cost-effective means to treat the injury. Most of the time, that's something like prescribing pain medication. That's also something like prescribing chiropractic treatment rather than, anesthetic procedures like cortisone injections or other types of pain management therapy, or even physical therapy that's a little bit more expensive.
I see. Okay, that makes sense. Now, when you talk about the policy limit, that's the maximum money that the insurance company will pay in an incident. What happens if the injury exceeds the policy limit? Like, let's just say Joe has a $15,000 policy, and Joe may have been drinking and driving and caused grave bodily harm to an individual, right? And now that person, lost a limb or is disabled or, heaven forbid, lost a life. And the family doesn't want to resolve the case for $15,000. Who's responsible for the remaining money?
Yeah, unfortunately, it becomes one of those situations where, under the contract with the person who has the insurance company is only on the hook for paying the policy limit. So, for example, if that's a $15,000 policy limit, the insurance company is only going to pay $15,000. They're never going to say, gee, he really messed up or we really feel sorry for this family. No, per our contract, we're only on the hook for $15,000. That's what we're paying. If you want to get anything above $15,000, you're going to have to sue the responsible party individually in court, meaning you're going to have to go to trial against him, collect a judgment, or if not trial, you're going to have to get a court to enter a judgment against the person and collect individually from them.
Okay. Now, would you think it's wise to, because I'm assuming the insurance company will give you a document that says, here's the money, you have to sign this so you don't sue us anymore. Do you think it's wise to sign that document and then sue the person?
Yeah, so when you settle for whatever the policy limit is, for example, if the insurance company says, we only have $15,000 of policy limits, if you want to accept it, here's a contract. If you sign this, we'll give you the money. What that contract also includes in it is what's called a release agreement, which releases your right to sue the responsible party who caused your injury. So by accepting and signing that contract, you're releasing your ability to sue that person in court.
I see. So if in the situation of Joe, if you want more than that $15,000, you shouldn't sign that contract.
Exactly.
Understood. Now, is there a situation, because I think you might have already answered my question. You said that the insurance company is not going to pay more than the policy. Is there a situation where you can get the insurance company to pay more than the policy?
Yeah, there are situations where you can get the insurance company to pay more than the policy. Now, typically, a lot of times you see obviously these billboards and advertisements for millions of dollars of settlements, right? Those don't come against individuals for the most part. These are against companies that have big commercial insurance limits. People who are, just everyday people, they find on the street, they're not going to be able to satisfy judgments, for even $30,000 or $100,000. They just don't have that money available to them, right? So it rarely ever makes sense to put forth a case and try to sue someone in court and put on a trial to try to pursue someone for a judgment above the policy limits unless you know for sure that they have the money to satisfy a judgment like that. But even then, even if they do, there's a lot of costs associated with collecting a judgment from them. So yeah, oftentimes it doesn't make sense to pursue someone individually. It often makes more cost-effective sense to settle for the insurance policy limits because the cost of pursuing someone individually often outweighs the added benefit or the added money you'll get from the individual after pursuing an action like that. Now, there are opportunities to pursue an insurance company, for excess policy limits. They're few and far between. Obviously we talked about the duty that an insurance company has to pay out the policy limits when they're presented with sufficient information and a reasonable opportunity. By sufficient information, I mean enough information. It doesn't have to be everything the insurance company requests. It's just enough information for them to assess, for any reasonable person to assess that, hey, this is worth more than the policy limit. We need to pay it out, right?
I see. So if you provide sufficient evidence, sufficient information showing that this case that you're prosecuting is worth more than the insurance policy, if I'm understanding correctly, the insurance company has a duty to tender the limits.
They have a duty, to tender the limit, meaning to pay your demand or pay whatever you're requesting, to pay the limit to the person who is injured, right? When they don't do that, when they've been provided with sufficient information, when they've been provided with a reasonable opportunity to tender those limits, and they still refuse to do so, they're acting in what's called bad faith, okay? Under California law, right, there's a cause of action for third-party bad faith where a person can recover and have the insurance company pay, potentially excess the policy limits because they didn't handle the claim reasonably.
So what I'm hearing here, it's a reasonableness test of how much information you've sent, if it's sufficient or not for the insurance company to tender over the limits. And I can bet every last dollar that the insurance company is going to say, no, I didn't have enough information here. We're not going to pay above. So who's there to decide if there was enough information and the policy is open?
Exactly. That's just an added burden of proof that we would have to present to a jury. It's up to the jury to decide based off of, how the law is written, whether there was enough information for the insurance company to tender the limits. Now, obviously, just like in any injury case, we'll present our arguments. The insurance company will present theirs. It's just an added level of burden that we have to show as a plaintiff to show that, hey, the insurance company was unreasonable when paying this claim. That's what makes these claims, these bad faith claims, very, very contentious, very costly, and very time consuming. So it's really difficult because insurance companies will fight tooth and nail on this because they don't want to pay a dollar over what their contract says they have to pay.
I see. And then ultimately, if there's no agreement, I imagine it goes to trial. And even when you go to trial and you get above the insurance policy, can the insurance company still stick their heels in the ground and say the policy's not open? Pound sand, I'm only paying you that $15,000 that Joe spent on us?
Of course, yeah. So what can happen is you could get a judgment from a jury above the policy limit, okay? But then you just have a judgment above the policy limit that you still have to collect on. Now, typically what will happen is the person who had the policy, they can assign their rights to the bad faith case because it's actually their case because they're the ones you're kind of getting screwed over by the insurance company. They're assigning their right to sue the insurance company to us, but then we'll have to pursue another lawsuit against the insurance company to recover the difference between the policy limit and what the jury awarded us. So there's kind of two lawsuits that we have to do in this kind of scenario.
Wow. So potentially there'll be two trials.
Exactly.
Okay. And there's a potential that the insurance company at one point they're going to wake up and say, uh-oh, we're in hot water. Let's just wrap this up before trial, and they'll pay above the policy before you go to that first trial.
It's tough, yeah, it's tough, but there are opportunities. It's usually when obviously the injury is very severe, and when it's kind of they knew that they messed up and they had an opportunity or they had ample opportunities to do so. But it has to, you know, we as attorneys have to present it as we gave them sufficient information and opportunities. We have to provide that support. We have to convince them to do that. It's very difficult to do that.
When I was asking that question, I kind of saw a smile on your face. So tell us about the most recent policy you just opened again. What were the facts there?
Yeah, this one I was really happy about because the client deserved it, and most clients deserve. A lot of our clients deserve more than the policy limits, but it isn't always possible on most cases. So we had a client who, we were retained by the client to litigate the case, meaning file a lawsuit against the insurance company because they refused to make a reasonable offer. Before the lawsuit was filed, they made a very low offer for her. She didn't want to accept it, had no alternative to file a lawsuit. Client honestly was a humble person, very believable, came from a very honest family, and didn't want to have to file the lawsuit, but she had no choice because the offer was so low. She had a very significant injury just based off of her medical treatment, but it wasn't necessarily evident in her MRIs or her medical records. So the insurance company treated it as a soft tissue injury and just refused to take it seriously for quite some time.
Okay, and what is soft tissue injury?
Soft tissue means like a non-fracture or like a muscle tear or a muscle pull or a minor strain, things along that nature. What soft tissue can also lead to, though, are real issues with your back, your neck, other body parts, your other joints that support your body. The word soft tissue actually gets mislabeled a lot because soft tissue can be more serious than a lot of compound fracture type of cases because depending on the extent of damage of the soft tissue injury and the extent of damage that your spine endures from these kinds of soft tissue injuries, they can be a lot more long-term than a fracture or something along those lines.
Okay, I feel like I'm talking to a doctor right now. So a soft tissue injury is kind of bleeding a slow death. And unless the lawyer knows what the symptoms can lead to, the evaluation of the case can be very low on a soft tissue injury.
Yeah, and the thing is, not all soft tissue injuries are major, right? A lot of them can resolve. There's a lot of soft tissue injuries that resolve in days. There's some soft tissue injuries that will never resolve. People will always deal with them. So it's really up to, it's an individual by individual basis. The soft tissue label is it's a very, as a lawyer would put it, vague and ambiguous term because it can mean a lot of different types of things. And it's kind of a blanket term that gets thrown around inappropriately.
Okay. Now, in this particular case, it sounds like you had to make a decision. You hit a crossroad, whether you resolve the case as just a soft tissue injury or you keep pushing it.
Yeah, basically, it was a situation where the full extent of our client's injuries weren't known at the time that we took on the case. But we believed in her. Honestly, she was always honest. We had an opportunity to meet with her and her family. Her treatment was real. Her pain was real. Everything about her case is real. I believe that she was going through a lot. And, we encouraged her just to keep on with her medical journey. Don't give up. Some doctors told her that, hey, we think the pain might be in your head. It might be something that, you're over exaggerating. But, we saw her, and we saw the kind of pain she was in. And something like that, when you meet a person, you get to know them on an intimate basis. They can't fake those types of things that she was complaining about. So we just encouraged her to keep seeking medical treatment. We finally were able to locate a specialist in the type of injury that she had that really kind of explained the full extent of her injury and what her future medical treatment is going to be and kind of what the rest of her life is going to look like with this type of injury.
Understood. And throughout this process, are you leaving the insurance company in the dark? I mean, what's going on that side?
So here's the thing, Ollie. This client wanted to settle her case as soon as possible. Every time she went to a new appointment, we would update the insurance company. We'd say, hey, this is still going on. she's still in severe pain, and we give them an opportunity to settle the case. Every single appointment she had, we'd send her medical records over. When she saw that specialist who said she had a serious problem, we sent his report over. And guess what? Every single time the insurance company says, hey, we don't think your case is worth it. We don't know if your case is worth it. We need to keep investigating to see if your case is worth it. But really, those things were all denials of her case. That they were denying her injury, essentially.
I see. So you're over-inclusive in providing documentation and records and information to the insurance company throughout the entire process.
Yeah. You can't hide the ball when you're trying to get an excess limit claim, right? We were trying to settle the case at the client's request. There were times where I thought, hey, I think we have enough information to say that you've blown reasonable opportunities times before, and she still asked us, hey, can you please just try to settle this case for the policy limit? I don't want to keep going any further. I just want to be done with this. I want to move on with my life. And we kept, at our client's request, trying to settle within the policy limits, and the insurance company just kept saying no.
Fair, and congratulations. So that all sounds very intimidating, and I feel like you have to be on point all the time. What do you do in your personal life to kind of keep you in charge the whole time?
Yeah, well, it's obviously being a personal injury lawyer, especially doing like civil litigation, it is you definitely have to have a passion to do it if you're going to do it well, right? If you don't enjoy the work, I don't think you can do a good job, especially on the plaintiff side. I just don't think you're going to have that empathy, have that drive to push for a client, because it really is a lot of work, right? It's a lot of work, and you have to deal with someone else's stresses, the client who has a lot of expectations and who's in a lot of pain, who isn't always in the best mood. You have to advocate for them on their good and bad days, and you have to do that on your good and bad days. So, I mean, I like to try to, compartmentalize the stresses of the job, and do other things like exercise, like to run a lot, like to work out. Exercise is a big thing for me. Reading is also a big thing, kind of being present in an alternative kind of state. It's cool because you can escape kind of like, don't get me wrong, I love litigation. I love personal injury. I wouldn't rather do anything else, but it's a way to kind of escape out of that, go to a different world, and just be very present when you're reading. And you learn a lot of lessons reading, a lot of great different perspectives, points of view. So that's something that I really like to do too.
Fair enough. I like that. I think those are all great things. I mean, you exercise, you read, you're like the epitome of any New Year's resolution. So I appreciate that. Thank you. And thank you for talking to us today. I appreciate everyone following. Follow us next week. I'm going to introduce you to a superwoman and a super lawyer. She's a full-time mom and attorney, Veronica Buckles. So hang tight and looking forward to speaking to everyone. Thank you.